Hi, welcome. Today's webinar is my first job, and this webinar is brought to you by LawWorks, a collaboration between the National Trades Union Congress and the Law Society Pro Bono Services Office. My name is Liansheng, and I'm your moderator for this evening. Before we start, there are some housekeeping matters. There are some relevant materials for today's talk which can be downloaded from the handouts panel on your screen. If you're using a mobile phone or tablet, the icon should appear on the top right-hand corner of your device. If you're using a computer, the icons are in the panel on your right. So please download these materials before the end of the talk, because once this talk ends, there won't be a link for you to download the materials. During the webinar, please feel free to ask any questions using the question mark icon on your screen. Only the organizers will be able to see your questions. And in the middle of our discussions, we will also try to address your questions and at the end of the talk as well. Please note that the discussion and materials provided for this webinar is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. And with that, we can start this evening's webinar. With me today, I'm very honored to have Mr. Patrick Tay and Mr. Ng Joo Khin on our panel. Patrick is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. Joo Khin is called to the bar in 1990 and has been active in many of Singapore's largest and most innovative transactions in recent years. He is recognized by legal publications as a leading corporate lawyer and capital markets practitioner. His clients describe him as a highly trusted advisor and praises him for his very strategic advice and guidance. Patrick and Joo Khin, thank you for joining us today.
Hello. Hi, everyone.
Hi. So, to start off today, what we're going to do is we're going to be following a fictional character, Anna, on her journey in terms of looking for a job, right from the start all the way till receiving the employment contract. And first off, of course, are the different roles that are associated with employment, as well as the concept of union, right? And with that, let's move to the slide. Yes, and this is the story of Anna. Anna has just graduated. She's looking for a job. Of course, the following roles that she can consider: there's an internship, traineeship, contract, part-time, full-time role. And Anna is also considering joining a union. Now, Joo Khin, what are the differences really, legally speaking, amongst all these roles?
Right. Okay. I think first of all, we have to start off with the understanding that these are not legal precise titles. In other words, it is not something which you can't find anywhere in the statutes where it defines what is internship or what is traineeship, what is contract role, part-time, full-time. It is really descriptions which are used commonly in the market, and it helps to describe the kind of responsibility. To a certain extent, it helps to describe the responsibilities that one would have if you're an intern compared to a trainee, compared to contract employee, and whether you're full-time, part-time will actually dictate the kind of, in fact, the kind of benefits that you expect. Now, let's just go down that list. Let's talk about internship. Well, internship really, most of the time you'll find people taking up internship while they are still undergoing education studies. For example, you will have, nowadays it's very common, and I use the legal profession as an example. We will have second year, third year from the National University of Singapore or the SMU asking for us to take them in as interns. And really, from the perspective of an employer, this person will be no more than coming in here to understudy maybe one or two, usually more junior staff. Maybe sometimes they can even be following somebody who is very senior. The whole idea is to help the person crystallize his or her desire to be a lawyer in the context of a legal profession. Now, it could happen to any other profession. It could be an accountant that opens up a space or two for someone to come in here to be trained, rather to be an intern, to see how is it really like to be actually having a career as an accountant, as an auditor. It could be even in a manufacturing setup where somebody would just go in as a management intern, where he or she will actually learn the ropes of learn a little bit about what a a manager would do, what a human resource manager will do, what even a CEO will do. Now, it is really a chance for them to decide for themselves whether this is really the profession they want to go into. Now, traineeship usually goes a little bit more than that. It is a time when someone will actually seriously undergo a training. Now, there are different kinds of traineeship. In the context of a legal profession, a trainee will be somebody who will actually undergo proper legal practice training so that eventually he or she will be called to the bar to be a full-fledged lawyer. Now, for a traineeship in a manufacturing concern, it will more likely than not be a chance, a year or two, where the person is training to take on a certain role. It could be that is to take on an executive role in the sales and marketing department. It could be a management trainee. Sometimes you hear this term called management trainee, where he or she will actually be trained in different departments within the company. Now, whether you are going to sign up as an intern or a traineeship, of course, it starts with what is being offered to you. But just to accept the fact that A and B, internship, traineeship, is really a chance for you to assess whether you like that kind of profession, that kind of career, and also for a chance for you to actually hone your skills in respect of that kind of industry that you are going into. Now, what about contract role? Well, I'd like to actually look at C, D, and E together. Contract role, part-time role, full-time role is really that you're already in the working life. In other words, you are not there to be trained, but you are actually contributing to the success of the firm, the company, by being part of the employment workforce. Now, if you talk about contract, it simply means that. It means that you are not considered as a permanent staff. More likely than not, you are there for a fixed period. It could be because you are there, they only need you for a period of time, or it could be that there is a project where it is just that project that they need your help on. So after the project is completed, or if for any unfortunate reason the project is aborted, then your role ceases, and the next thing you will find yourself either being redesignated another role, if let's say your contract is a fixed term, or they will just probably give you a notice to say that, okay, your contract ends right now, and therefore you have to move on to another job. You have to look for another role outside of that company. What about part-time and full-time? Well, this actually, D&E actually, it actually describes a role that is a little bit more permanent than a contract. A contract role will tell you more likely than not there is a fixed time period. But a part-time role may not have an expiry to your role with the company, but it means that you are not expected to be performing full-time, 8 hours a day, 5 days a week. It's likely to be that within the day, you are required only to perform maybe 4 hours, 5 hours. Sometimes it could be 2 weeks out of every month. Whereas full-time role is what we commonly call an employee, where you are expected to commit your time, dedicate your time almost full-time. Of course, within the confines of the law. Anybody who works more than 40 hours, for example, would expect certain overtime pay, certain limitation as to what is the maximum number of hours that a person is expected to perform in the week, or rather in the month. And of course, like what I said just now, there will be different kind of benefits for contract workers, for part-time workers, and for full-time workers. A full-time worker definitely will have the full suite of medical leave, medical care, insurance cover, and you sometimes will have other benefits like compassionate leave. You might even have leave to look after your children, leave to, when you have a newborn, you will have paternity leave as well as maternity leave. All these things will matter whether you are taking a contract role, a part-time role, or full-time role.
Sure. So really when it comes to the different roles, what I hear from you, Joo Khin, is that there seems to be some differences in the work time, in the job scope, yes, including the entitlement that you might be, or the benefits, yes, of compensation. So Patrick, really, so in terms of practically speaking, how is it different? Do we make sure that we must have the right roles assigned to us when we are looking for our jobs, or what?
Yeah, I think, yeah, thanks, and thanks, Joo Khin, for articulating some of the legalities behind these various combinations. So I think it's very important, as you can see, all A, B, C, D, and E. I'll just go through them from well, an NTUC labor movement perspective. You know, how to navigate, particularly if some of you who are tuning in or in fact watching this webinar, some of you may be in some of these relationships, or should I say employee, or maybe sometimes not in employment relationship altogether. So it's important to look up some important tips. I think at the end of the day, one very important fact is whether there's an employment relationship, i.e. whether there's an employee-employer kind of relationship throughout, whether it's A, B, C, D, and E. Because you can say one thing, well, it's substance more than form. So I think if you can establish an employment relationship, it's important, because when there's an employment relationship, a lot of things, not just what Joo Khin shared, over and above that, some of the statutory benefits, responsibilities as well, and duties will kick in. For example, the Employment Act. For example, the Work Injury Compensation Act, and other labor-related legislation, including CPF, etc. So you have to take note of that, because one, there's an employment relationship, which is the one that is most important to establish. That's a bit of the legalities. But otherwise, if you look at each of this, if I may just chime in what and you know, reiterate what Joo Khin mentioned earlier about C, D, and E. Important, firstly, of course, to be able to ascertain that there's an employment relationship, well, there's a common law approach to it. Basically, meaning, well, they are to ascertain whether there's an employment relationship. We look at precedents and many of the decided cases. Well, there are certain rules. We don't go to the legalities, but you know, there are various tests, and there's quite a number of judgments at various levels in court in Singapore to decide whether there is in fact an employment relationship. But otherwise, if you look at a contract role, part-time role, full-time role, as long as there's an employment relationship, a lot of the obligations and rights will kick in, the statutory ones, including the common law ones that are usually implied because of the employment relationship. So therefore, it's important as you take on your first job to see what is provided, not just in the employment contract, and whether it's clearly articulated that there's an employment relationship. Mostly in the unions, we have and seen many part-time and full-time roles. So in most part-time and full-time roles, there is obviously a employment relationship in most cases, unless they do it in a very ambiguous manner in the employment contract. But otherwise, when you see a part-time role and full-time role, there's usually a employment relationship. Yeah, so both the common law and the statutory benefits and responsibilities all will kick in. However, in the contract role, as Joo Khin mentioned earlier, usually it's for a fixed term, to be as short as 1 week to as long as a couple of years. You also again need to ascertain from the employment contract whether in substance, not just in form, in substance there's already an employment relationship. That's important. However, all said and done, in most contract roles, there is an employment relationship. So that's for C, D, and E. For A and B, these are, well, usually for students and or for new entrants into the job role or sector, but increasingly in the last couple of years, particularly last year because of COVID-19 and all the other attendant challenges, government has come up with various traineeship programs. So it's important to dichotomize between internships and traineeships. If I may say, internships are usually referred, as Joo Khin mentioned earlier, for students, usually in our ITE, polys, and even autonomous universities, when they do internships during the school holidays as part of the curricular and program, to do internships with companies. And therefore, in this case, there's no employment relationship per se. Yeah, but important to take note that Ministry of Education actually watches this piece quite closely. I actually, brought this topic up a couple of years back while filing a parliamentary question, because if you recall, a couple of years back, there was a big viral YouTube video going around where the intern was being battered and assaulted online. You can watch it. I don't know whether the clip is still available, but that sparked off a lot of debate on the issue of workplace bullying, in particular of interns. So I think following from that and following from the response from the Minister of Education from that parliamentary question on better managing interns, the MOE actually works very closely with the schools. So the schools, or should I say the institutes of higher learning, IT, polys, and autonomous universities, do actually pay a close attention and do company visits, etc., to make sure that the interns, and to check in with the interns as well, to make sure that they are fairly treated at their respective internship workplaces. My main worry, because I've been interacting with a lot of young workers as part of the young NTUC outreach, the worry is sometimes they are overworked. Anyway, they're interns, so they're made to do very menial stuff, and it really deviates from the original intent. Depending on what trade, what sector, what company, varying practices, but essentially not to be overworked until it becomes a workplace safety and health issue. I think that's basically internship. So internship, there's no law per se. They don't get covered by the Employment Act per se, because they are not in the employment relationship. However, there's all these other regulatory and penal measures which can be undertaken if there's any workplace safety, health, or harm caused. For traineeship is an increasingly used term. Some call it traineeship, some call it these are a few very, very current terms because of these 5 rounds of budget we had last year. We had traineeships, SG United traineeships. Some of you have heard this term used. It's been very widely publicized. There's also the mid-career kind of traineeships, meaning the traineeship don't just apply to new entrants or your first job or first traineeship, but also to mid-career individuals who may have been retrenched, laid off, and moving into this sector. So that's the traineeship. Sometimes you also hear the word apprenticeship. Sometimes you also hear work trial. So essentially, good to take note of all these terms. And again, they are all nomenclature, but traineeship is a bit different from internship. Today, as we are talking, a traineeship often referred to not just the traditional traineeship, but the SG United traineeships, which I know many of you are tuning in, maybe in some sort of a traineeship arrangement. There are about easily 20, 30, the last count I heard is 30, 40,000 people on these traineeship arrangements. So in such traineeship arrangements, important to take note that it's not employment contract. It's not employment contract, so the attendant rights and obligations or benefits of the employment contract don't kick in. So therefore, you need to take a closer look at the traineeship contract. There is a traineeship contract that is an agreement that is worked out between the trainee and the receiving organization. In Singapore, the SG United Traineeship Program is being run by the Singapore Business Federation in partnership with different sectors and different sector agencies, and including the unions. So therefore, good to take a closer look at what's provided, and if they face any issues, again, they can still bring it up. I also raised this point on what if trainees are kind of mishandled or they face grievances. So Ministry of Manpower, as well as through WSG, as well as Skills Future Singapore, including NTUC and the labour movement, you can seek recourse, or we can give you advice on how to navigate some if you face any grievance.
So there's something I'd like to add. In fact, there's another term, talking about terms, there's another term that you might actually come across quite often, especially when an employer once try to shirk his responsibility of giving you certain benefits. He will call you independent contractor. So this is something which you need to be aware of and look carefully at what you're signing. Because if you are treated as an independent contractor and the employer or the so-called employer can establish that indeed you are actually not to be treated as an employee, then there are certain things that he will not need to provide for in the course of you working for him. There has also been instances where they will tell you that, oh, if you are independent contractor, you do not need to pay your portion of CPF, you get higher take-home pay. Now, all these things you need to be aware that there are certain implications. While you may not need to contribute your part of your CPF, but you still have your MediSave that you need to contribute to. And more importantly, it means that the employer does not need to contribute to your CPF if you're an independent contractor. Now that actually affects in the longer term your entire remuneration.
Now, Patrick, and Joo Khin, I hear from you about independent contractors, about attendant liabilities and rights that come if there's an employment relationship. Does joining a union help further protect my interests? Because that's something of young workers.
Yeah, thanks for the question, Liansheng, and thanks for the leading question. Of course, I would say, coming from the NTUC, the labor movement, definitely if you are a union member, even better still, union member in a unionized company, there will be greater protection and greater avenues, more avenues, and if you face grievances at the workplace. So looking at A, B, C, D, and E, and of course, if you ask me, anybody can join the union. I think the key thing is about two things. Firstly, for those in an employment relationship, you can join the union. At the same time, also you can be represented in some instances, or should I say in most instances, unless, of course, you are excluded. What do I mean by representation? So the union can actually advise you and represent and act on your behalf if you face any workplace issues. So if you're in an employment relationship, you're a union member, you actually can seek recourse. If you are working in a unionized company, you can approach the union leaders or the industrial relations officers. That's if you are a unionized company. If you are not in a unionized company but a union member, if you do face any issues, you can also have access to the Tripartite Alliance for Disputes Management, TADM for short. It's a tripartite alliance for the reason being non-union members can have access to it as well, because it's co-manned by Ministry of Manpower staff as well as staff from NTUC. So, however, if you are a union member, in a way you get a more bespoke service, and we have full-time staff actually attending to you, and also, of course, attending to your issue or grievance. However, for internship and traineeships, in most instances, there's no employment relationship. So if there's employment relationship, no issue. Come to NTUC. However, in internships and traineeships, usually involving students, usually involving people who have not actually effectively joined the company. So there are two levels. Firstly, because of in the Trade Unions Act, or should I say the Industrial Relations Act, some of the rights, privileges, and will kick in only if you have a union member. But the Trade Unions Act actually prescribed that there must be sort of an employment relationship. So if you don't have, technically we don't have an opportunity to represent you in that sense of the word. However, all is not lost. We have our young NTUC and NIBO membership, which many of them in the ITE, polys, as well as universities. You'd be surprised, quite a number of them actually are our members, our youth members, so to speak. So we have this category of membership where they can sign up as a NIBO or young NTUC member, and then we can assist them by giving them advice through our industrial relations practitioners, to the young NTUC team, as well as myself and my colleagues in the legal department at NTUC. We are also supporting young NTUC. So behind the scenes, we can assist you and advise you accordingly, even though you're a student member.
Now, what about what Joo Khin was saying, those independent contractors? You said in order to be part of the union, you may have to be an employee. What about freelancers or independent contractors? Can they go to a union and seek some form of membership?
Yeah, thanks Liansheng for that. In fact, about 4 or 5 years ago, the labor movement started moving into this space. What we call we set up a freelance and self-employed unit, because some freelancers or independent contractors come in various forms. They can be freelance professionals. Otherwise, they can be self-employed, running a business or trade or partnership, and therefore there's actually a several level of access. Like you rightly pointed out, the Industrial Relations Act and Trade Unions Act don't apply to them, but there's no employment relationship. However, what we have done is that we have band everyone together in this various freelance crafts for example, at the Private Hire Vehicle Association. So we have formed associations to bring freelancers together. And as an association, we lobby and advocate for them for various rights, privileges, and as well as whenever they face, policy obstacles, we do assist them through, advocacy and lobbying efforts. So that's what we have done for various groups. For example, like the private hire vehicle drivers, for the taxi drivers in the National Taxi Association, for the coaches, the National Instructors and Coaches Association. At the same time, also with the latest one, the last mile delivery, personnel, we had the delivery champion. So these are example associations where you set up to help them with the advocacy. However, if they face issues, most of the time, not so much with the employer because there's no employer, usually sometimes the buyer, but also sometimes increasingly these days, the platform or the buyer of his or her services. So that's where the problem comes in. When there's a late delivery, late payment, there's non-payment, there's underpayment, or sometimes even breach of intellectual property rights. So that's where we advise them through legal primers like today's session through this partnership. At the same time, also the Tripartite Alliance for Disputes Management, just slightly more than a year ago, have started allowing freelancers to access their mediation services and when they face problems with buyers. Again, it's mediation, so it has to be voluntary on both parties. So these are some of the recourse available, as well as a whole series of tripartite standards which govern freelancers, including the payment of freelancers. So these are things that we have done. No legislative effect, but sort of a quasi-legislative effect to say what are the best practices and what buyers of services, including the public sector, should comply with.
Thank you, Patrick. At least, thank you, Joo Khin, as well. Very, very good overview of the various roles, as well as the concept of union, as well as rights and obligations of employers and employees. Now, let me move on. Now that Anna has gone through the various advertisements and then looked through, and then she has been given some offers. Okay, and that's the next scenario that we are going into. Where Anna starts applying for jobs, and then of course she gets offers from companies that she has applied jobs with. The scenario is this: on one day she gets an offer from a company which says, "Can you do this job for $2,000?" And then another day, company B calls her and offers a similar job, but the salary is higher now. Okay, and then she calls back the first company and says, "Hey, actually I've changed my mind. I will be going with another employer now." Okay, Joo Khin, do you think Anna is allowed to change her response to company A? Would it make a difference whether there was an oral agreement or a written agreement, or or that is prior to the signing of an employment contract?
Well, okay, I think the basic principle is that for a contract to be created between two parties, there must be offer and acceptance, and the offer and acceptance can be verbal, so it does not need to be in writing. So the very fact that company A actually has, and I'm assuming that the person calling her has the authority to make that offer, actually offered her the job over the phone and she accepted it. In principle, that is actually a contract. In other words, Anna has accepted it because there was an offer. Put aside, some of the arguments as to whether, all the terms and conditions are there, and therefore does it really constitute employment? Well, the basic thing is that she has accepted an offer. For her to now go on to accept a second offer and then try to kind of like revoke what she has accepted as the first offer, it's going to create a little bit of a legal issue. Now, of course, there are ways that a clever lawyer will help her to get out of the first contract, arguing all sort of things. But if you ask me, a straightforward answer would be yes, she has already accepted an offer and she is bound by the first contract. And if she's going to go back to company A to say that I changed my mind, well, if the company A is nice enough to say, okay, never mind, we move on because anyway you have not started with us, that is fine. But if company A wants to be really difficult, she has to resolve it, because she cannot just walk away to company B. Now, more likely than not, it is company B. If company B does find out later on that she actually has accepted company A's offer, and company A is not happy to let her go, there is a possibility that company B may then say that I can't proceed with my offer to you because you are in breach of another contract, and I company B, do not want, representing company B, would not want to be accused of causing you to breach another contract. So it creates a lot of legal uncertainties. So it is very important for Anna to think carefully when she said yes, before she says yes to the $2,000 offer, especially if she thinks that there is going to be another offer coming soon and she would like to consider that offer. Never think that she could just take this first and then think about revoking this offer when she gets a better terms on the second offer. It's not wise. If she wants to think about the second offer, or hoping that the second offer will come quickly, perhaps could ask company A to give her some time to consider before she said yes. Or a very logical way of dealing with it is to say that, oh, I would like to have a look at the contract before I say yes to it. Would it be possible for me to have a copy of the contract to know exactly what are the rest of the terms and conditions before saying yes?
So Anna always has a choice to wait it out, to you know, look at things carefully before saying yes.
Yes.
Any other practical, Patrick?
Yeah, sorry, I was muted. I just want to emphasize that I think I've met many workers and union members who are exactly in such a predicament, exactly this scenario. So this scenario is not fictitious, it's actually real. I've actually come across, and quite a number of them have consulted me, similar situation. In fact, I want to give two scenarios. Firstly, totally agree with Joo Khin. Please think carefully before you say yes over the phone, before you give a WhatsApp message to agree, or even sign a dotted line. And not just yes, agree, sign a dotted line, but at the same time also please read your terms and conditions, and of course employment contract front to back. Yeah, however long it is, however short it is, please read it front to back, even the fine print. Very, very important, because we have come across, or I've personally come across a situation exactly spot on, where a person agrees and then subsequently changes his or her mind because another offer that came in was so much more attractive and doing the same job, and therefore trying to rescind the earlier one and trying to get into the new one. And lo and behold, yeah, she receives a legal letter from that first employer whom she agreed with to start work, and therefore sued for damages, and of course not just damages but whatever attendant responsibilities as stated in the employment contract of the terms. So do watch out for it, including notice pay, etc. So watch for that, be careful. But the other situation I want to alert everyone from a practical point of view is increasingly there are arrangements where companies get their potential employees to be sponsored for training. So I've also seen quite a few number of cases where they go for training, could be government subsidized, where and then company pays X dollars, or sometimes company pays for the full cost. And mind you, some of these programs are rather expensive, and it goes to 5-digit number figures, and therefore please, whatever the case may be, there may be some condition precedents or even condition subsequent for undertaking that training, and then before even you start work, you may have certain obligations to fulfill. So please look at the fine print, whether it's verbal, whether it's contractual, or even simple agreements or simple training agreements where you undertake training and then with a view of settling in or working as an employee after the completion and passing of your training. So please, handle all this with care, because I personally seen a few of these cases. Well, if you meet a well, a progressive, a very enlightened employer, a very nice one, well, they may waive the need to pay back some of these damages or training costs. But I've also seen employers who really bite to the end. So do be careful, because unfortunately the legal obligations will catch up on you.
We do have some questions from the attendees, and one of the questions actually relates to your point, Patrick. When looking at the employment contract and let's say in the scenario that you have painted, where this potential employee is sent for training before the commencement of employment, when does the employment relationship start? And are there certain things that must be present in the employment contract before we can say that there's an employer or employee relationship?
So very important. Yeah, that's a good question. So read the fine print, because even before you start the training arrangement, there's usually the company will make you sign. Increasingly, I'm seeing a lot of companies sending people for training. Could be 3 months, 6 months, 9 months, a year before they start work. And there's definitely obligations, because the company has to fork out X dollars. So therefore, please read your training contract, or well, they can coin it in different nomenclatures and terms, whatever they may be. It could be just a training contract, but please read the fine print, because the training contract may subsume with it some of the employment. It may say that at the day when you start a training, you technically are an employee already, because there are some arrangements where it's a place and train. I mean, some of these schemes where you actually place and train, meaning that the first day you start training, it's already your employer. Because how do we know that? Because many of the training funding and subsidies in Singapore are employer-supported training and funding. So therefore, you need to be an employee before you enjoy some of these training subsidies, for example, with Skills Future or some national grants of sorts. So usually they presuppose that there's an employment relationship. So handle with care, read the fine print, and if you're not sure, ask the receiving organization. It could be the training academy, because some employers actually have training academies. They are their subsidiaries. So whatever it is, just be extra clear. You can clarify either with the HR department, the person that sponsors that training, or the employer that may be taking you in after your training. So whichever party it is, do check the fine print. Very, very important.
Since reading the employment contract is a very important thing when it comes to your job. Joo Khin, are there any important key employment terms that we must look out for when we are reading employment contracts that are given to us?
Well, I think the first thing, of course, just make sure that the salary that you have actually been expecting is actually recorded very clearly in the employment contract. Especially if it's not just the base salary. If let's say there have been promises of allowances, don't take it for granted that the employer will automatically give it to you just because he spoke about it during the interview. So if let's say you're expecting a base salary of 2,500 per month, but actually the real substance in your package for doing the job is really the commission that will be promised to you, because you bring the clients, you bring the customers, you bring in the new contract, then make sure that that is actually stated very clearly. And watch out for things like they just make it very, very kind of like very vague to say that, oh, you will be awarded incentive payment for good performance, and everything is just verbal. That actually creates a room for them to be difficult later when it comes to you bringing the $1 million deal, and yet they decided that they only give you maybe a very small percentage, much less than what they have been painting to you as good bonus or good remuneration. Besides that, of course, if you have expectations in terms of leave, whether it is annual leave, whether it's medical leave, hospitalization leave, what about insurance cover, you should actually find out all about the benefits that you will get as an employee rather. A lot of times these benefits are not written in the main contract you signed, so there will be usually an employment handbook It could be all contained inside your employee handbook to actually map out what are the benefits that you will receive as a full-time staff, part-time staff. If you're contract staff, there may be some other benefits, but less. Now, all these things you should actually take note of and ask for a copy of the handbook before you sign on. Now, of course, if you think that the base salary is good enough for you and these things do not really matter, you can go in and find out after you have signed the contract. But if it does actually matter to you a lot, please read before you sign on the dotted line. What other terms and conditions in employment that I will look out for? Termination. I don't want to go into an employment situation where I suddenly realize that when I have a very good job, after working in this company for 3 years, and I've honed my skills and I've actually become more valuable in the market, I want to move on to another job, a better role. I realized that I've got to give 1 year notice because I've signed something that says I've got to give 12 months notice, otherwise I pay at least 6 months of compensation to the company. Now that is going to be like what we call a poison pill, of making you less valuable in the market in a sense, because you can't just walk across to another better job. Of course, we always encourage people to stay for the long term with the company, but everybody got their aspirations. You may decide to go into another field, another industry. Another very important clause that I would look out for is to see whether there's any non-compete undertaking. What do I mean by non-compete? There are actually industries which are sensitive in terms of their client information, in terms of their trade secrets. So there will be very often clauses that say that you cannot make use of the company information when you leave the company for another job. And sometimes it's drafted so widely that it almost stops you from working for another person. Now, of course, the law does protect. Somebody cannot bind you for life. They cannot make it so difficult that you cannot even earn a living after leaving the job. However, there will be situations where you realize that, hey, actually you have signed something that make you, again, to use the same phraseology, less valuable to your next employer. Now, that will actually limit your ability to progress in your career. So do watch out for what you are signing, especially in the non-compete undertakings within the contract itself. So besides this, well, I can, one other term that I would actually look out for will be whether there is any limitation on whether you can do something else other than the job itself. Now, of course, most employers will not allow their employees to double heads. In other words, work 9 to 5 on one job with the company, and then after that at night you're doing something else which may actually affect your performance the next day. So look out for any of these restrictions. If you really need to do 2 jobs because of circumstances, then do make sure that it is made very clear with the employer that you intend actually to become a secondary job at night or over the weekend.
No, Joo Khin, we also have some questions.
Liansheng, I know there are some questions, but if I may chime in and also do a bit of a advert at this juncture that in fact today, as we are having this evening's legal primer, LawWorks legal primer, as part of this primer, we are also launching the 2nd edition, or should I say the updated edition of My First Job Pocket Series, the LawWorks Pocket Series. We've been doing a pocket series for a series of topics, and this we have kindly given everyone a soft copy of it. You can download it. It's part of the handouts. It's a great a great copy to equip yourself with, particularly if we are preparing for your first job. And many of the things that we are sharing this evening, including some of the questions that we have put up on the chat, are answered in that on that pocket series. It's located, I think, for those who have registered, it's in the handout page. You can download the soft copy. At the same time, we will get the organizing team to give you the web link. You can share your friends. I'll probably post it on social media pages later on, so that you can direct people to get a copy of it. It's free of charge. There's no charge for it. It's compliments of this LawWorks partnership between Law Society Pro Bono Services Office and the Labour Movement. So we have provided some of the quick FAQs for each and every one of you before you embark on your first job. So do read. It's a simple bucket series to read. You should be able to read front to back in less than 20 minutes.
Yes, it's very helpful. I remember reading it for some of even my own corporate advice when I have to give to people who approach me. But this is the second edition. It's amended and is relaunched today. That's very helpful. One of the so one of the questions that was quite interesting, because we do see quite a number of questions about part-time employment, and I thought maybe it's good at this juncture to deal with that as well. Insofar as part-time employment is concerned, one of the questions raised was, is it necessary for an employer to offer a written contract, even if it's a part-time position? What are your thoughts?
From a practical point of view, definitely as well. Why do we always ask for a written contract? For this obvious reason, to have greater certainty, to avoid disputes and more contentious litigation thereafter. So I think it's always good to have everything in black and white, so to speak. And in fact, there's actually a tripartite advisory on key employment terms. It's available. I think, if I'm not wrong, the booklet does allude to it. At the same time, also the MOM website and the NTUC website also provides a link to this tripartite standard on key employment terms. So in fact, we have done this, addressing actually, of course, the intent was to assist many of the lower wage workers, but many of them could be in a very precarious or vulnerable position where they just do certain odd jobs on a part-time sort of basis, on a contract sort of basis, and it's basically by word of mouth. I pay you X dollars, and you just come to work every other day. So we were quite concerned because we were getting quite a bit of this at the heartlands and on the ground. So we have come up with this tripartite standard, so to speak, and therefore now employers are required as part of this tripartite guidelines to issue key employment terms, the terms which actually Ng Joo Khin earlier alluded to, maybe not so technical as the non-compete clauses, but basically the important general clauses, for example, hours of work, salary, when is salary payable, etc., etc. Yeah, so that's basically it. So there's a long answer to your short question. In fact, whether it's part-time, contract, in whatever sort of work you're entering into, always try to get it in black and white if possible.
Yes. In fact, whenever we talk about freelancers as well, we also encourage freelancers to have written agreements between their service clients and themselves as well.
So, I think my experience is that a lot of times the difficulties faced by freelancers, for example, is not really that they do not have a written contract, but very often they are said that they got no choice but to sign whatever is dished out in front of them. And I think that is something which hopefully with maturity of the society, employers will be a little bit kinder to allow, especially freelancers with limited exposure to signing contracts, time to seek counsel from somebody, or at least time to review the contract before signing. I think I put it this way: if the whole contract the whole part-time work is just an hour's work, and it doesn't really take a lot of efforts or time, and probably the amount involved is maybe $20, $30, I would not go and fight over a contract term, the terms of the contract. But the minute you go into a part-time job, where especially if, let's say, that part-time job requires you to put in some of your own resources, materials, like for example, a freelancer who is asked to put up at an event some decoration, and the freelancer is expected to come up with his own money first to buy the materials, then you want a contract. You don't want a situation where you buy the materials, he turned around and said, actually, I don't like the color, and then he just walk away. Not because he doesn't want you to work on it, but he just want to use that opportunity to squeeze you on some more on your contract price. So avoid such situation as far as possible. Yeah.
However, whether you are full-time, part-time, or contract, if there's an employment relationship, do not fear. If they don't have a legal written contract, that's why I said whether you're in an employment relationship is very important, because there's all else fails, there's the Employment Act. So if the company doesn't fails to provide very clear terms on sick leave entitlement, annual leave entitlements, etc. I think later on questions will be on this. But I saw that question on the chat, so I thought to address this. Employment Act sets basic rights and privileges, notice periods, amount of leave, annual leave entitled to, sick leave entitled, medical reimbursements. All these are provided in Employment Act. So if all else is silent, the Employment Act sets the floor, a baseline kind of privileges and rights for each and every one. So not to worry. I know some of you may be in a precarious position where you just do work for a month or two, or maybe 6 months, or maybe a year, and then it's all verbal. Worst case scenario, you still have the Employment Act to fall back on.
Okay, let's move on to a more challenging situation. Now that Anna has received the employment contract, she has signed it, and then she is given an employee booklet, like what Ng Joo Khin said, that sometimes some of her leave entitlement or other employment benefits are in the employment booklet. And there's a discrepancy. So between the employment booklet and the employment contract that was signed, there is a discrepancy in terms of the number of days. There is also a discrepancy in terms of the offer that was made over the phone, as well as the employment contract that was signed. Joo Khin, what would your advice to Anna be? How should she approach such a situation?
I think it's back to that, that advice that I think Patrick and myself has been emphasizing. Read before you sign. So if let's say the offer over the phone is indeed for $2,500 per month, but the contract came out to be $2,200, I think the first thing that Anna should really do is not to sign the contract, not to expect to sign the contract and later on argue that it should be $2,500, because a written contract would more likely than not be seen as overriding whatever has been discussed. And also the question is that unless she tape recorded the whole thing, how would she be able to prove that it was said to be 2005? Because if the employer just said that, oh, I think you heard me wrongly, it's 2002, and she already signed it for 2002, it's very difficult for her to basically ask for 2005 thereafter as a matter of right. Now, employee booklet, handbook, employee handbook. Very often you will find that in the employment contract, and if I draft something from my client to use as an employment contract, I will make sure that there's a reference to the employee booklet or employee handbook inside that contract. So therefore, once you see something like that in your contract, I think it is only right for the employer to share a copy of the booklet before you have to sign on the dotted line. So if let's say the employee booklet actually states 14 days, but what the main contract says is 21 days, then it all boils down to whether there is actually clarity in the contract itself to say that in the event of inconsistency between what is published as standard employee handbook and what is written in your main contract that you sign on, that it should be the contract that overrides the employee handbook. If you have that, it's clear. But if you do not have that, then it becomes a question of contractually what was actually seen to be as agreed between the two parties. Now, if I were to fight a case, I would say that the handbook, especially if it's not handed over to you at the time of signing, I would argue that the 21 days will actually take precedence over the handbook, which has never been given to you when it was signed. But in the I think that it is still better for Anna to take a quick look at the employee booklet, especially for terms like leave, medical benefits, etc.
Now, Anna may ask for the handbook, for example, but before signing, can the employer say no and don't provide her a handbook before signing? How should she negotiate such a position with her would-be employer?
Well, practically speaking, sometimes it depends on the bargaining power of each party. If you're in a situation where you know that it's difficult to get the job that is being offered before you, I think that the pressure will be there for Anna to just sign and move on. and hope that the employee handbook will not contain anything that would be really to her disadvantage. Well, I think at the end of the day, the good thing is, as Patrick has said, there's Employment Act to protect. So, employer cannot just put something inside the employment handbook that actually goes against, firstly, the basic law. So if the law says that you cannot work somebody more than X number of hours in this industry, you cannot put in there to say, notwithstanding the law, you have to work X number of hours or more than that. But I guess at the end of the day, Anna can actually insist if she thinks that she has the bargaining power to do so. If not, then just take a look at the employment handbook immediately after she has signed it. I'm sure the employer will provide her with a copy. And as soon as she discovers something that is really wrong, then I think that she will need to decide whether it is better to, if it's really that bad, whether it's actually better to move on to another job, or to bite the bullet and see how to renegotiate with the employer. Not sure whether, Patrick, you got any other practical tips for them?
Yes, I think I have two pointers for our, prospective, my first job new entrants. I think two things. Firstly, would be to take note of what your skills, competencies, and experience are worth. So before you jump on the bandwagon to see whether it's 2.2 or 2.5, there are actually a lot of benchmarks and proxies you can use because there's industry salary benchmarks. MOM publishes them, many HR consultancies publish them. It's available off the net. So you can get a sense through even My Careers Future websites to get a sense of what's the salary, or should I say the range of salaries for that particular job and job responsibility. So that will give a good gauge whether you're off tangent. So not so much on to negotiate. Well, it helps. For example, like they're underpaying you, or you think they are giving you a very, very low offer, and you can actually cite instances where perhaps on My Careers Future portal, LinkedIn, or even some of these salary benchmarks they are available, because all these are very useful data. The plethora of data out there, especially in the MOM website, where you can get in very, very specific job scopes and what the median mean salaries and ranges. So do a bit of research if you want to know how much the job is worth, and therefore you can better negotiate. So that's tip number one. Tip number two is if you're joining a unionized company, since earlier on we're talking about unions, do check whether there's a collective agreement in the company. Because in most unionized companies, we have something called a collective agreement. So if you're a union member, you will be covered by the collective agreement, and the collective agreement in most instances provide much more generous benefits than what is stated in most employment contracts and for non-members. So if you join a unionized company, be a member, and you can have access. If you're not sure, check the union, check NTUC, drop us a line. If you want to know whether this company is unionized, you can call us and check with us as well. So that when you go in, your eyes open, and you can even access and know, some of the benefits under a collective agreement, which may be extended to you at whatever level of the hierarchy you're in.
Oh, that's very useful.
In fact, there's just one more thing, maybe, especially for the if you are first time applying for a job and first time accepting an offer of the job, it will help if before you actually, and you know that you're going to be offered a job, because they probably call you up and say that we are keen to have you. Can you please come in to sign the employment contract? Now, what you can do actually is that the day before, sit down, have a very clear mind to think through what are the things that would matter to you in the employment relationship. So, for example, do a simple checklist for yourself. Salary, okay? Make sure that if they already told you over the phone that it's 2005, make a note there, so that when you read the employment contract, you straight away will be reminded that you have to look out for this term. So just do a simple checklist on the terms that matter to you. For example, if you know that you definitely need a certain number of days per year for annual leave because of your commitment, a family commitment or whatever, then put a note there so that you will check it off as you read through the employment contract. Very often I've seen people rushing through their employment contract and they suddenly go blank and do not know what to look out for. So that might actually help you to be a little bit more careful before signing the contract.
Yes, those are very useful tips. Let's move to the next point, because we have about half an hour left, and I want to keep some time for the questions that are coming in.
Sure.
There are also some questions relating to this aspect, which is the side hustling aspect. Because more and more people are trying to, earn money in addition to their employment income. And this is a scenario that I have posed for the panel today. Now that Anna is working in a company, it's been told to her that she has a probation period. But at the same time, let's say on weekends, she actually has an Instagram account and she sells cookies or pastries online through her Instagram handle. Sometimes she drives Grab in order to pay off her petrol costs or the cost of her car, for example. And because of her expertise, she may also freelance as a marketing consultant for some of her clients outside. In such a situation, maybe I start with Joo Khin first. Let's deal with the easier part. Well, what does it really mean when they say that you are on a probation for 3 months?
Right. I think the idea of probation means that they are watching you quite closely for this period. As much as they are watching you, you are also entitled to watch what is the company doing to you as an employee and what kind of environment you are in. Now, usually during a probation period is typical for an employer to actually be able to terminate the contract at shorter notice. And also there may be adjustment to your salary or other benefits only after the probation period is over. There has also been many instances which I've seen where if for any reason during the probation period an employee did not perform up to scratch, then the employer sometimes may extend the probation period or may actually decide that at the end of the probation period, they have to basically give a notice to terminate that relationship. So I think probation simply means that you're under watch, if you put it in a very, very colloquial manner. Yeah.
No. Then Patrick, what about the side hustles? What do you is Anna able to do such side hustles while she's in full-time employment? What are the implications on her if she does such things?
So, like just to add on to what Joo Khin mentioned, take note. Many of the companies, whether you're probation or whether even you're full-time employment or even part-time employment, especially when there's employment relationship, please take note. I know, for example, some of the civil servants, public sector requires you to seek permission if you want to do any side hustle or do any, sometimes we use the word moonlight or do a second job. So be careful, do check with your HR department whether you are allowed to do so. In most instances, companies do require you to seek permission. So it's a never blanket allowing of you to take on a second job. So do be careful. We don't want a situation where you get into trouble in the other freelance job or your side gig or your side hustle, and then it sometimes goes on social media or it does affect your main job, so to speak. So take note of that. But the other one to take note of is also the fact that when it comes to I know Liansheng is going to ask me that. How about CPF and income tax? As you know, in the employment relationship, there's always the payment of CPF by the employer. At the same time, also the payment of income tax. These days, auto-generated, or should I say auto-included. But when you take on some of these gigs, take note, whether it's A, B, or C, sell pastries, Grab driver, or even marketing consultant, all these, whatever you earn is still income. So as IRAS speaks for itself, income tax. So anything that's income is taxable, whether you just do a small gig, big gig, or side hustle. When there's income, my strong recommendation, please declare it, and therefore income tax is payable for all three scenarios. Then you may ask me, how about CPF? Okay, CPF is, as you know, have two components: the employer component in the employment relationship, the employer component, and the employee component. So in such a case, company B is required to pay the employer portion of the CPF. However, what if we are baking online, doing Grab driving and marketing consultant freelance? So we presuppose this is a contract for service or independent contractor or gig arrangement, where it's a freelance and self-employed arrangement. So the CPF Act or CPF actually has a provision for self-employed personnel. So what then is this provision? So if you are working company B and you're allowed to do some of these side gigs or side hustles, and you make an income out of these, and if the net trade income is more than $6,000 a year, you may be required to make some contributions, particularly to MediSave under the CPF Act. So take note, add up together. If it's net trade income of more than $6,000, I repeat again, more than $6,000 only annually, then there may be obligations as a self-employed person to contribute a certain portion to MediSave.
You answered my questions, because I know of that really, because I work as a lawyer, but I also have a side hustle as a playwright. So, so these are things that I have to be concerned about as well for my income tax matters. But you can't run away from it. I think most of the time it will happen. But I have an interesting question from one of the attendees, which is, if the employer agrees to an employee's side hustling, are there any legal ramifications that you see might be possible that might happen to the employer?
Well, let me start then on this. Now, I think one of the things that we have to always bear in mind is that even if the employer very generously say that, oh, please go ahead and do your part-time job at night, it doesn't affect me because it's your time. Never go away with the idea that you can do anything that would cause harm to your company. In other words, for example, the scenario that was painted, I think that is geared towards one aspect. For example, if you are a marketing executive in the company that is selling, let's say, hand sanitizer in the COVID period, at night, you actually part-time with another company that's also selling hand sanitizer, but a competing brand. Now, that is going to be an issue, because as much as your employer say that you can go and do your part-time work at night, but I don't think any employer will accept that you are doing a part-time work that is competing against their own products, or that is going to cause damage to the reputation of the company. So do bear in mind that even if you get a very generous employer saying that you can do your part-time work, you have to ask yourself whether that actually has a ramification, legal ramification, especially on the reputation of your company, on competition landscape that your company is facing. You're giving consultancy to someone who is going to compete against your company. I think that there is a fiduciary duty as an employee that you would have breached by then.
Yeah, actually, if I'm not wrong, actually the common law also provides for a law of fidelity, meaning for the employees, they must do things in good faith for their employers as well.
Yes.
So it's not as simple sometimes when you want to do side hustle. Yeah.
Yes.
Yes. One more question. Insofar as independent contractors are concerned, this is a question from an attendee. Am I allowed to do multiple side hustle jobs? Patrick, do you have an answer for that?
Actually, much depends on what. We are assuming that the employer allows you to do side hustles. So I think some employers are more progressive, more enlightened. They say, if we can, you decide to do something else, be a tuition teacher or be a photographer, freelance photographer. There are no restrictions. Again, please check your employer. Well, the main employer is the one, that you need to be extra, careful with, because don't push the limits lah. Sometimes they may allow you to do 1 or 2 gigs, but then you decided that you want to do more, please, whatever it is, do seek permission from your company that where you have an employment relationship with, especially on those side hustles. It's a matter of not just fidelity, but also your credibility in the company. Whether your attention is actually on the company, or so you may kind of like go off tangent and work against you. So we'll be careful. Yeah, we don't want it to, all these side hustles to affect your performance, and of course at the end of the day your performance appraisals.
And I would add that if, let's say, if for any reason they have agreed that you can do some of these sidelines, over the weekend or whatever, it is good to actually put in writing so that there's no misunderstanding. Because you may be speaking to one HR manager who say, oh, no problem, go ahead. But lo and behold, the CEO, when he finds out, he may not like it. But if you have it in writing, at least you could defend yourself.
And sometimes it may be a workplace safety and health issue. Here you are working 9 hours in a job, 9 to 6. After work, you start doing Grab driving. I mean, it's fine, but if you start doing into the wee hours of the night, because sometimes you do have the jobs coming in by your Grab app, and or whatever side hustle you're doing. It could be a nighttime DJ, whatsoever. And it may cause a workplace safety and health issue, because at the next day when you go to work, you may be like still not fully well rested, and particularly if you're doing some of the jobs which require a lot of focus, attention, and maybe a safety hazard to yourselves and the people around you. So do be careful. I mean, I've come across workers who, for a variety of reasons, sometimes to put food on the table, having to take on more jobs. Yes, you can, but handle with care. Don't tire yourselves out and then cause a safety hazard to yourself and the people around.
And another aspect that you need to take note of is that doing another job with permission is one thing, but using the company resources to do your second job, you need to be very, very careful about that. If your employer is really generous and say, oh, fine, you can stay in the office to do your second part-time your part-time job, that is fine. But don't think that just because he said, oh, you can do your part-time job means that you can use the resources of the company to do so.
Those are very practical tips, actually, whether it's income tax, about health, your own health as well, if you're taking on multiple jobs, about your relationship with your main employer. Those are very, very important tips. We have a question of probation, which is also discussed at this slide. There's a question about whether there are any difference in entitlements during probation period and after, or if there's any basic restrictions, or are there any restrictions against employers extending probation periods without a limit?
Because I've been seeing quite a number of these cases. So as far as even when you start a job, there's already employment contract. But some of the benefits only kick in after a period of time. So take note, for example, like sick leave, annual leave benefits may only kick in after 3 months, etc. So please take note. Some of these are provided in the Employment Act, and as well as in My First Job pocket series, which is available to all of you for downloads or through the link, which has been just updated. And you do refer, all these are available there. On the second question on whether probation can be extended, yes, it's at the prerogative of the employer in most instances. Probation may be 3 months, may be extended 6 months. Some because there are jobs at a higher level of hierarchy, the probation may extend from 6 months to a year. It depends. It varies from job to job. It varies from organization to organization, and varies from industry to industry. So there's no fixed practice. But yes, I know many employers extend probations for a variety of reasons. Some maybe because the performance is not up to mark, or they feel that they should. The employee may need some more time to be assessed whether he or she can be confirmed. Likewise, also sometimes extended because maybe the company is going through a difficult period. For example, COVID-19, where they may not have the capacity or to hire or to increase hiring after the probation period. So these are things that you need to look out for. In most cases, the terms of the probation and what can or cannot be done and what rights and privileges are usually also provided in the employment contract. So do take note to read the fine print again.
So so in relation to probation, I have a question, which is also quite related to what the attendee has asked. So as probation is concerned, do you foresee a situation where, for example, the employee can also give termination, or must the employee serve out the entire probation period?
Well, based on what I've seen, typically I think that the notice period still applies both ways. In other words, I have not actually come across any employment contract that says that during probation period you are not allowed to serve notice. Or maybe there may be, but it is not typical. And I think that it is the usual, whether it's a 1 month notice, whether it is shortened during probation period to 7 days. I've seen a variety of that. Yeah.
So you usually cut both ways?
Usually you cut both ways.
The only instance I remember coming across a bit of an issue happens when earlier I alluded to the pre-employment training, or should I say the training as part of the employment. Yeah, sometimes there may be requirements for a person who has completed the training that's sponsored by the company or employer to serve out a probation period. So there's a minimum sort of like a training bond of sorts. I would call it probation, but sort of a training bond of sorts. So that's usually provided when they reach out the training and supports your training. But sometimes during training, you may receive a stipend, an allowance, or even full salary, depending on different companies have different practices. So don't take note of the fine print, because sometimes there may be a training bond. I've seen quite a number of cases where, you know, after the training, they start a job and really commit some safety breaches, etc., or already may not be up to it, or they themselves are unilaterally may want to feel that they are not up to this job and want to move to a different job. Take note of this obligation. There's sometimes, usually, if the training is very generous and it's very costly, will come with a training bond.
Yes. We have about 15 minutes left, which I want to reserve some time for the Q&A as well. So let's move into the Q&A. I have a very interesting question, which is not legally related, but I think it comes from some of the attendees who are young adults seeking their first job. There is a question which they want to seek the wisdom of our panelists tonight, which is, do you think, insofar as your first job is concerned, whether you should try to go into a specialized field or a more generalized work?
Yeah, I shall take this question then. Since having assisted many retrenched workers and being very, very, in the trenches in this period of time. Of course, what's happened in the past year with COVID-19 has caused quite a strain in the labor market. I must say, the retrenchment numbers last year was slightly more than 26,000, almost 2.5 times that of 2019, which is about 10,600. So and the unemployment rates were like, for Singaporeans, I think blew past 4.5%. Fortunately, the figures just released yesterday seems to suggest that things are getting better. But definitely, it's a very, well, I should say, a very soft labor market. So for many of you who are taking your first job, I don't know whether you have a luxury of choice. Some of you may, because you may have very good skills and competencies. And you have the in-demand skills, so to speak. But otherwise, as a practitioner and having dealt with the unions and handling many of these retrenchment, layoffs, and even job fairs and placements, my suggestion is, whatever it is, I mean, important to see where your strengths, your passions lie, and your interests lie. Whether it's a specialized or general, I don't think there's it's wrong to go in a specialized job and then worry later. I think even in a specialized job, you will be able to, at the same time, pick up some of the skills, some of the general skills in the course of your work. So I think whatever opportunity that comes your way, if you think you are up to it and you think you want to give it a shot, I think be open about it. Some of you may be going to new industries, never heard of industries, or even new jobs which you didn't really study back in school. My advice is take on whatever that's available. Yeah, give it a shot. The reason why I say this is because in the labor movement, we have analyzed a lot of the labor market statistics. Our biggest worry is when you are ready or want to do a job, but you KIV that, and the longer you stay away from the labor market, the harder it is to re-enter. Yeah, then there may be questions from employers as well when they interview you. Why are you, why weren't you at work the last 1-2 years? What happened? What's the reason or motivations behind it? So stay, whatever opportunity comes, of course, again, subject to your passion, skills, and interests. Take on whatever it is, whether it's specialized. You can at the same time pick up many of the skills, the horizontal skills, or should I say the T-shaped skills, even if it's a very specialized role. There's a lot of trainings, a lot of opportunities. And it's up to you as a person to build your credentials, to build your skills, amass experiences, and of course your networks. And at the same time, there are a lot of national funding programs to encourage individual initiated training. So there's no short of support for training. In fact, myself, I'm going for some skills future training next week and next 2 months to also try to stay ready, relevant, and resilient. Yeah. So anyone, I mean, even for first job entrance, please do that.
I guess the important thing is to keep an open mind. The world is no longer like 20 years ago where somebody can stay in the same role, same job, same company for years, and they look towards retirement, and that's it. In today's world, things change so fast. New technology comes out every now and then. Even some of the at the managerial level, they have to relearn their skills, even if they're staying in the same role, in the same job. So same thing. If you go into a specialist position, keep a lookout for other aspects of training, especially in your free time. There's nothing to stop you from learning more things, and be on the lookout for changes in the market. I think that's more important. So even if you are in a specialist kind of position, watch out to see what is the development in the industry that you are in the space that you are working, and if there are any potential trouble or problems that may surface, then start preparing for changes.
Those are very... Patrick, go ahead.
No, I was just saying I wanted to try to answer some of the questions, because I also have I saw a question earlier on whether a company can ask for a copy of your NRIC prior to signing an employment contract. Since I'm on the personal data advisory committee, I thought useful to advise on this as well. And as a general rule, PDPC has come up quite explicitly that there's no need to, there's no legal right to collect NRIC numbers and even retain NRICs. However, take note, there are some exceptions to this requirement, or should I say, this rule on non-collection of NRIC numbers as well as physical NRICs. Few exceptions, for example, if they ask for your last 3 digits in the alphabet, I think that in most cases that's permissible. Again, there's consent obligations under the Personal Data Protection Act. So if you consent to it, yes, you can. However, there are other situations. For example, like where it's another exception is when it's legally required by law. For example, you're entering employment, for example, to be a private security officer. There may be some screenings to be done, and therefore they may require an NRIC number to do the relevant screenings, to do the relevant checks. For example, you're going to practice as a certain profession, certain regulated, highly regulated industries. You may be required to provide your full NRIC number for purposes of checking on, example, criminal backgrounds and other necessary security checks. So if that is required as part of law, a part of written law, then they may collect from you. The last situation I can remember is where they are required is employment agencies. I think through the Employment Agencies Act, will have powers to collect NRIC numbers. Off my head, I can't remember the exact amount. For certain jobs above certain salary thresholds, they are actually allowed. They are actually given permission by law under the Employment Agencies Act to collect your NRIC number. So these are the various scenarios where your NRIC, you may need to give your full NRIC number. But again, it's specific to job. If they do it for anything else, then it can make noise.
Well, practically speaking, your employer will need your NRIC number for purposes of preparing your IRA and also for purposes of submitting to the CPF. So, but I think what is important is that they cannot abuse, the information that is provided to them. So they can't take your NRIC number, for example, and sell it to a marketing agent to use it. Yeah, that's certainly against the law. So yes, more likely than not, you will have to provide your NRIC, but you know that it is for limited purposes. Yeah.
That's good to know. One related question: what about health information about a potential employee? Am I obligated to disclose if my potential employer asks me of it?
Yeah. Whenever, I mean, there's a Tripartite Alliance of Fair Employment Practices, so they should not discriminate you. However, because of most of the time when they ask for medical records or ask for medical health history, two scenarios. Firstly, when there's a job requirement, for example, it's a very strenuous job requiring a lot of climbing, carrying of heavy loads. It's more of a safety requirement to know whether you have a back injury or you ever dislocate your hands or whatever. So in most instances, I know companies ask for medical records or medical history to make sure that they themselves don't breach any safety and health laws as well. So that's one. The other one is also for insurance purposes and medical health insurance purposes. So most companies provide medical benefits and some cover. So for underwriting purposes and of course to cover to ask you for a declaration, so that they need to also do the necessary declarations when they are claiming insurance for whatever benefits, hospitalization, etc. So just take note of these two. However, they can't discriminate you if it's for reasons, unless well, in most instances they have to prove that why they require that medical checkup or health records. But from what I know on the ground, most companies do require workers to go through a quick medical checkup. Different professions, different industries require different comprehensiveness of checkups. Yeah, some may be very cursory, some very, very detailed. They even take MRI scans and stuff like that. Well, in most cases that I know, I come across, is as per what I mentioned earlier, because of the job requirements, safety and health requirements, and for example, they don't want you to be predisposed to certain, maybe if you have predisposed illness, and then or you're predisposed to certain allergies, for example, and then you're coming into contact with chemicals and fumes, and so they don't want to aggravate your condition and then get into a difficult situation. And the other one is, of course, the insurance companies, where they provide coverage for each and every one of their employees.
Well, for example, the employer, you can actually request the employer for insurance purposes to actually provide your medical information directly to the insurance company, rather than through the company if that is really sensitive. And I think that some employers do oblige that because really the information is required for the insurers to consider.
Okay. Of course, there's another related question about conviction records. Are employers entitled to ask if I've been convicted before?
I've seen quite a number. Like I said, it depends on the also industry, depends also on the nature of the profession. Yeah, I know certain industries don't ask for whether they are criminal records. There are industries, for example, like the financial sector, security sector, where because of the screenings that need to be done, they need to ask preliminary and sometimes also your NRIC numbers because of the screenings that are going to be done to get you licensed, to get you authorized to do certain job, or to allow you to enter certain premises, certain prohibited or restricted areas. So these are the things I've come across where they require you to answer those questions. However, there is actually a Registration of Criminals Act, which I think, well, more than a decade ago, there may be certain instances where certain offences, not the more serious ones, the more lighter ones, will be spent. This concept of law called spent, meaning that you will no longer be in your criminal records, and you need not declare it as part of a conviction or an offence that which you have committed. So they are prescribed, I think, in the schedule, the kind of offences, number of years before it gets spent, and so do take note of that. And maybe it's just, for example, if you are involved in some petty theft and you're a young boy, or and then got away a fine, or maybe just a probation, etc., etc. So good to check. I don't have off my fingertips, but I know certain lighter offences may be spent or removed or purged from the criminal records pursuant to the Registration of Criminals Act.
Yes, and that ties up the Q&A session. It is 8 o'clock. I just have to plug some of the resources that we have prepared for you. Like Patrick mentioned, my first job, the primer, the booklet, the pocket series is available for download. Please download. It contains many useful information that you can look through. It's very small, thin, but it gives a quick summary of things to look out for when you're joining your first job. There are also resources that are available online at the Law Society Pro Bono Services Office. Like Patrick mentioned, there's the tripartite dispute management agency out there, which actually sets out what are the key employment terms to look at. How do you deal with conflict in your employment, etc. Yep. So these are all useful resources. Please have a look at that. And with that, we have come to the end of the seminar. Patrick and Ng Joo Khin, anything else to add?
No, I said the resources are out there, and please download them. If you miss the download, you can always go to the web link or go to both Law Society Pro Bono Services Office as well as our NTUC websites to access a soft copy of it. Yeah.
And then I just would like to just end by saying that when you're facing challenges and troubles, there are sufficient agencies. There are many agencies out there who will be able to extend help to you, whether on a pro bono basis or on a small fee basis. So do not feel as if you're alone out there. There are a lot of people who have been through many of the problems that you're facing. You'll be surprised that there are already solutions out there for you. So just look out for help out there, and yeah, thrive well in this environment.
Yes, and with that, thank you, Patrick and Ng Joo Khin, really for sharing many useful tips to our attendees today, sharing your experience and knowledge. For the attendees, I have to say that we will be sending a form to collect your feedback after this seminar so that it can help us improve our future webinars as well as our LawWorks series, what are things that we can look out for and assist you with. Last but not least, thank you all for joining us today, and everyone have a pleasant week ahead. Thank you and good night.
Good night.
Good night.
Take care.